Attendees are in listen-only mode.
Hi, everyone. Thank you for joining us for this third Thursday training on changes in Maryland law for 2019. My name is Amy Hennon. I'm the Managing Attorney for Housing and Consumer Law. Chris?
And I'm Chris Sweeney. I'm the staff attorney here as well, and I manage the Workforce Development Project.
Hi, I'm Heather Hyman, and I'm the attorney that manages the Human Trafficking Prevention Project here at MVLS.
So the way that we're going to run this is that there's a questions box that you all are welcome to throw questions into. I can't promise we're going to be able to answer all of them, but we'll try. As you can see on the screen, we've got information for how to keep in touch with us on social media. And if you click, you can see that there's a handout in the handouts box of the for the webinar. It has the slide presentation that we put in there, and all of the links in it are live. And so, for instance, that mvls.org/events link, if you're later looking for where to find our upcoming trainings, you can click on that link. And then once this presentation is over, give us a few days and we'll get this uploaded onto our website if you want to check it out, if you want to check out the video later. And with that, I think we'll go ahead and jump into the presentation.
All right. All right, again, my name is Chris Sweeney. I'm the staff attorney in charge of the Workforce Development Project here at MVLS. And I'm going to talk about sort of the goings-on in expungement law. The truth is there actually were not any changes made to the expungement law this year, but there were a couple of interesting attempts to make changes, and those attempts continue to gain traction, so we thought it would be a good idea to alert people to that. There were two bills that were amendments to the existing expungement law that failed last year, and I wanted to go over a couple of the important changes that were trying to be made. One of them was really just a fix to what is Criminal Procedure 10-110 and part of the JRA, or Justice Reinvestment Act, that authorized a lot of expungement for people who were found guilty, which was previously not available. And that even includes felonies as well in a couple cases. One of those examples is burglary. The JRA made it possible to potentially expunge conviction for first, second, or third degree burglary. However, for whatever reason, it did not include fourth degree burglary. So currently, if you are convicted of fourth degree burglary, it is impossible to expunge that case. However, if you were convicted of the worst degrees, you are potentially eligible for expungement. That was one of the major changes in one of the bills that unfortunately did not go through. The other changes that were attempted were including convictions on major or incarcerable traffic offenses, so misdemeanor traffic offenses that do carry the possibility of incarceration. So things like driving on a suspended license, driving without a license. These are all things that, for whatever reason, again, were omitted from the JRA and the comprehensive legislation that allowed for expungement of guilties. So those are things that are continuing to affect the unit rule, which blocks expungement if a single charge in a case is ineligible, and continuing to affect the subsequent conviction rule, which blocks expungement if an ineligible case exists within a certain time period after conviction or PBJ that would otherwise be eligible. So unfortunately, those attempts did fail, but they are gaining traction, and some of the other ideas that are gaining traction is a push, again, to take care of that traffic conviction problem either including traffic convictions in the list of potentially eligible convictions or exempting those traffic convictions from the unit rule or the subsequent conviction rule. That would be at the very least. And a sort of stretch goal would be to get the JRA to include all misdemeanor convictions and possibly with just some limited exceptions. And another stretch goal would be pushing for the elimination of the unit rule altogether, which is something that is also gaining traction. So those are just some things to be aware of that could be on the horizon for expungement law coming up. There have also been some new events happening in just general expungement practice that you might be aware of if you are practicing expungement. There's an ongoing issue with hearings being called specifically at the Wabash District Courthouse in Baltimore City, where attorneys and even people without attorneys are filing for expungements that appear completely eligible on their face. There is no objection being submitted by the state's attorney, and then a hearing notice is coming in on that case. And that's even happening for things like a null pros from years and years ago and other types of cases that appear to be eligible. It's also another important thing to look out for in that same vein is a lot of petitions where the charge is possession of marijuana and there was a guilty, which has been eligible for a couple years now. And the latest update to the statute is conviction for possession of marijuana is eligible after 4 years, essentially no questions asked. There's no subsequent conviction rule. There's no amount in question. Something that continues to happen in Baltimore City District Court is a hearing gets called with no state objection, in that case with the marijuana, and occasionally the court is demanding some sort of proof of how much marijuana, which used to be an issue, but the law has since been updated. It is no longer required by the statute. So that's something to be aware of, that you just may be called to a hearing. So we've had to incorporate into our practice warning the clients ahead of time and even warning volunteers who are doing expungements. We used to be able to tell volunteers and clients that expungement was more or less a done deal, simple process, that there wouldn't be a hearing. Now we are having to warn them, if it is in Baltimore City District Court, that a hearing is possible. And even in some circumstances, clients who don't show up to the hearing, even if their attorney shows up and there's no state objection, that is occasionally being denied as well, just for the client not being there. So that's very important to be aware of. And then a couple little things that have been happening is the courts sometimes are saying now that the state of Maryland needs to be named as exempt from liability on a potential claim in the general waiver and release. It's been common practice for a long time to include the arresting officer and the arresting police department. But that's just something we've been seeing here and there, is to include the state of Maryland to avoid getting things rejected. And there is unfortunately the possibility that certain cases just get flat out rejected for an incorrect reason or for no reason at all. So that is just something out of our control that we thought expungement practitioners need to be aware of as an unfortunate possibility. And again, this is happening in Baltimore City District Court. And then one final little anomaly that we've noticed going on in Baltimore County District Court is the employees there, maybe even including some of the judges, seem to be misinterpreting the rule around probations before judgment. So there's the 3-year rule, which states that you can file for expungement of a PVJ the longer of two periods, being the date that the PVJ happened, 3 years after the date that the PVJ happened, or after the ending of the probation, whichever is longer. So that essentially means it boils down to it's extremely rare that the probation itself is longer than 3 years, so it's pretty much always just 3 years after the PBJ was granted. Certain people in Baltimore County District Court seem to be under the impression that the waiting period is 3 years after the date that probation ended, no matter what. So, for example, if you had a PBJ and the probationary period was 1 year, they are considering it to essentially be 4 years from the date that the disposition happened. So the 3 years is starting to tick after the 1 year probation, which is incorrect, but it is an interpretation that's causing filings to get rejected in that county. So those are just new events in the expungement world that we thought people should be aware of if you're practicing expungement law. And that'll conclude my little section of the presentation, and I'm going to hand things over to Heather now.
Thank you so much, Chris. Actually go back, I skipped a little bit ahead. I wanted to talk about 4 bills that were considered at the General Assembly during last year's session, and that were of concern to the project here that is working with trafficking survivors in Maryland. Again, my name is Heather Hyman, and I run the Human Trafficking Prevention Project. And we at MVLS and through this project are part of the Maryland Human Trafficking Task Force. And there were a number of bills that were considered during this last session that the good news is 3 of those bills did pass, and 1 thing did not pass that we are going to be putting renewed focus on for 2020. So first, looking at the bills that passed that are going to be taking effect on October 1st. The first bill is the Safe Harbor Act. Its official title is the Child Sex Trafficking Screening and Services Act. And this bill basically provides funding to ensure that minors can get services if they've been trafficked. And it also creates a new regional position, basically a point person, to coordinate supportive services for minor victims. The bill also mandates data collection so that there can be better informed responses and allocation of resources for agencies that are providing services to minor victims of trafficking. So this was a welcome piece of legislation that was passed. One unfortunate thing that did happen, though, one caveat, is the bill originally as written included a provision that would have provided minor victims with immunity from prosecution, and that did not make it through in the final bill that was passed. And it's unfortunate because the ability to prosecute minor victims really goes against, I think, what advocates and what survivors, of course, would see as being best practice. And it also contravenes federal and state law, where in most cases, minors that engage in commercial sex are automatically deemed victims of human trafficking that are entitled to services and that should be protected. So hopefully that's something that can be addressed in the future. But again, we're glad that there is additional funding that is being made available, and these regional coordinators will, of course, help handle these types of cases going forward. The second bill that was passed is the Recodification Act, and this was also a very important bill. As you can see, it relocates the trafficking statute, takes it out of the prostitution subtitle and puts it into the crimes against persons title. And it clarifies a bunch of inconsistencies that were in the law in multiple places throughout various statutes here in Maryland. And one reason this is really important, just taking a step back, is it really, I think, ensures the crime of trafficking is given the gravity that it should be getting by putting it into that crimes against persons category. It also is going to help dispel this myth that sex trafficking is the only form of human trafficking. As we know, it can be sex and labor trafficking that can occur. And so this repositioning is really important to address those 2 things. The legislation also clarifies the felony provisions of human trafficking, ensuring that they're defined as a crime of violence which is going to have an impact on perpetrator sentences and on probation. And then this bill also clarified that lack of knowledge of a victim's age is not a defense to felony charges of human trafficking. So these are some very important clarifications that occurred with this bill. The final act that was passed that I wanted to mention is the Labor Trafficking Act. The official title was the Anti-Exploitation Act. And this bill, it's important to note that until this was passed, Maryland had no state law that specifically prohibited labor trafficking. We were actually one of only 3 states in the country that lacked this, so this was a needed correction. And the new legislation that's going into effect, it basically both prohibits a person from knowingly inducing someone to perform services or labor through force, fraud, or coercion, and it also imposes criminal penalties if a person knowingly receives a benefit from someone who's forced into labor, even if they didn't do the act of trafficking, manipulate someone through force, fraud, or conviction or coercion themselves. So if you knew that trafficking was going on, you could be criminally liable if you received a benefit. So it's great that those 3 legislative priorities were passed. Unfortunately, there was one thing that made it through the House and was stalled with the Senate Judicial Proceedings Committee, and that was a bill called the True Freedom Act. And that bill would address the vacatur statute that we currently have in Maryland. And this particular piece of legislation was particularly relevant to the work that we do here at the Human Trafficking Prevention Project, because we do vacatur cases. We are always looking to see how we can assist survivors of forced marriage in completely clearing their record. And with prostitution convictions, if for whatever reason you are unable to get a prostitution conviction expunged, and if you have been subject to forced fraud or coercion and meet the legal standard of qualifying as a human trafficking survivor, vacatur is a really important remedy to be able to address those convictions. So this proposed legislation would have made critical improvements to Maryland's vacatur law. Maryland was one of the first states to pass a vacatur law a number of years ago. It was a second after New York. And unfortunately, though, the law that we have is now widely perceived as being one of the worst laws in the country. In a recent study that was conducted by Polaris Project, Brooklyn Law School, the ABA, and our partners at University of Baltimore, they basically gave Maryland's law an F grade and noted that of all the states that have a law similar to the vacatur law that we have, that we're basically the worst in the country. And one of the reasons for that is because the law is extremely narrow in scope. It really only lets you address prostitution convictions. And we know that survivors of trafficking often have many other things on their record. They might here in Maryland have, loitering convictions, drug-related charges and convictions. They might have trespass, be convicted of something called perverted practice. There's a whole range of things that survivors often are grappling with outside of just a conviction for prostitution. Another problem with the law right now is that under its current configuration, there's a requirement that you have to get approval from the state's attorney's office prior to even filing a motion to vacate. This is potentially even unconstitutional. It hasn't been challenged yet, but that is one thing that this legislation was looking to address. And we were very lucky last year. There was support from the Maryland State's Attorneys Association for this legislation. And so we are looking forward to reintroduction of this legislation during the 2020 session and hopefully being able to make some progress with this bill so that we can improve protections for survivors here in Maryland. And with that, I will hand it over to Amy to talk about a wide range of issues that have gotten updated during the last General Assembly session.
Thanks, Heather. This is Amy Hennon again. I'm going to kind of run through a number of different topics. The first I'm going to touch on here is family law. That is always a there's always a robust area where there's always a lot happening in the legislature, and this year not a lot happened at all. There were two important bills that did come out of the legislature this year. One is a somewhat minor change, but is important in a lot of family law cases about extraordinary medical expenses and how that goes into calculation of additional child support that might be owed, or who's going to be responsible for what. And so now HB 742 is now law, or will be as of October 1. And so any medical expenses above $250 are considered now extraordinary medical expenses, and this is only going to apply to medical expenses incurred after October 1. And then the other major thing that passed was a work group to study child abuse and domestic violence, and how to properly protect victims in both of those instances, and through what the state courts can do. And there's a report that should come out hopefully soon, a few more months, and then the final report, an interim report, and then the final report would be in June. The sort of usual round of bills that we often see in Annapolis, having to do with being able to terminate parentage when the child is the product of a rape or incest, getting rid of child marriage, making infidelity no longer a crime. The one that's made the rounds the last couple of years about parenting time, all of those came up again, none of them passed. So it was not a particularly big year in terms of family law, but there were these two changes. And so maybe we'll see something come up next year, or maybe the year after, from the Child Abuse and Domestic Violence Study Group, but that will remain to be seen. In the estate law context, we had something important happen for, at least in terms of our clients. SB 261 was a sort of minor change in that it changed the statute from a may statute to a shall statute, so it now requires the Register of Wills to waive the filing fee, which can be a couple $100s at a minimum for relatively small estates where the person is getting help from a Maryland Legal Services Corporation funded organization like MVLS. That's going to take effect October 1. And so this is going to be a very much useful tool in terms of our ability to get those filing fees waived for low-income folks, that especially where the only property is a home, and if they're potentially facing an issue with tax sale, and they need to get the property into their name. In order to get things like the homeowner's property tax credit and get water credits and all those other fun things. There was another significant bill in the estate law context that has to do with the spousal elective share. And where that comes up is if somebody wants to disinherit their spouse, there is a spousal elective share that spouse, if that spouse has been disinherited in the will and that they've said that the spouse should get nothing, that this new bill that will go into effect next year is going to look at both probate and non-probate assets, and ensure that the spouse receives that the spouse receives is taken care of. And this is obviously important when you're talking about maybe a second or third marriage, especially when there are children from previous relationships. It's a big deal. But if you're counseling somebody who wants to potentially disinherit their spouse, the only real way to do that is to get a divorce. That's really what's got to be done. But it's a lot more complex than I'm making it. And there are some much longer training programs, half-day, full-day training programs talking about the spousal elective share and how to properly write a will and how to deal with all of these things, especially if you're dealing with clients with more than just a few assets. So we can't get into all of that right now. In the foreclosure context, there was one significant bill. There used to be some mortgage, if you were the recipient of mortgage debt forgiveness, there was a federal bill that said that was not a taxable event for you. That was sunsetted. Maryland decided to make that permanent for state taxes, but it's still a potentially taxable event for federal taxes, but it's not a taxable event for state taxes. And that bill took effect June 1. In the tax sale context, we saw a couple of important things come out of the tax sale that are a really big deal. HB 1209, actually both of these two bills on the screen, HB 1209 and SB 96, both of these bills saw a number of revisions during the legislative season, and the end result is generally a very positive one for a lot of low-income folks. Something that we had not seen at all in the tax sale context was any data tracking, and that's going to be one of the things that's going to be required from HB 1209, and also providing information, getting more information out to homeowners that are in tax sale. So those are the sort of two important pieces, and that's going to go into effect in January. SB 96 really only matters for Baltimore City residents, but it means that residential property, so that could be owner-occupied or non-owner-occupied, so that's going to include rental properties, in addition to houses of worship where they have the appropriate exemptions with this, et cetera, with the state, that those are going to be exempt from the water bill sending the person to tax sale. Those properties can obviously still go potentially to tax sale if we're talking about more than $750 in property taxes owed, but it takes water out of that calculation, because it used to be water would up into and including 2019, tax sale included water bills. If there was even $1 of property taxes that was owed. There was a little bit of a back and forth after the legislative season ended about exactly what SB 96 meant. And there's since been an Attorney General's opinion that's come out that said, no, it means that water bills cannot go into tax sale. So that is good and important. There's one other tax sale bill that went through that is less important for MVLS clients, but important to just know that it happened. And that was SB 509. And that allows all of the county, that's a may and not a shall statute, and allows all of the counties and Baltimore City a potentially separate process to get vacant homes back into productive use. And this is only vacant homes where the total liens exceed the value of the property, but it gives them an in rem option, or a process by which they can potentially not send that process through the normal tax sale lien process where the lien gets sold and then the lien is later foreclosed on, but potentially Baltimore City or one of the counties could just put the property up for sale and get that property back into productive use a lot quicker. So that will hopefully eliminate some blight issues and help statewide. And then just in the water context in Baltimore City, the one other thing that I would note that was not part of the state legislative season, but is ongoing right now, is the Water Accountability and Equity Act. There's actually a work session at City Hall next Tuesday at 10 a.m. That bill is going to would create an Office of the Customer Advocate that would be responsible for helping resolve disputes. It would make tenants currently are not necessarily entitled to water bills from the Department of Public Works, the water company. It would make tenants the customers of the water department. And then the other thing that it would do was ensure that water affordability complies with the United Nations standards for affordability, meaning that no more than 3% of someone's income goes to water. So that would be really important, especially for low-income folks, and we're hoping that that'll pass. Lots of stuff happened in sort of the student loan context that is especially important for low-income folks. So people are getting more and more aware about predatory for-profit institutions, and there have been some for-profit institutions that have been attempting to convert to nonprofit status. HB 416 is an attempt to to prevent them from being able to do that. There was also HB 464, and that is requiring a number of things for-profit institutions to provide to students to make sure that that they're making an informed decision about what they're really getting into, and that information needs to be displayed prominently and put on the website. Both of those bills have already taken effect. And then there was one other bill in the student loan context, SB 670, that just strengthened the student loan ombudsman, the student loan office, the student loan ombudsman office. Last year there was a bill that created an office with the Department of Labor Licensing and Regulation, which is now just the Department of Labor, and that created the student loan ombudsman office. And this year there was a bill to strengthen it and allowing that ombudsman to take more action on behalf of student loan borrowers. So that will go into effect October 1. And with that, we have come to the end of what we really wanted to talk about today, about various changes that have occurred that are going to impact low-income folks in Maryland. If anyone has any questions about anything we talked about, I don't see any currently, but you can go ahead and throw them in the questions box. But you can see on the screen, if you are looking for ways to get involved with MVLS, you want to take a pro bono case, you can go to our website, you can click that volunteer drop-down box, and you can see the pro bono, you can click on the pro bono portal. The attorney resources option is where you're going to find previously recorded trainings. This training will go up in that attorney resources box. And this is what the pro bono portal looks like once you click on it. And it'll have various different case types that you can sort by case type, and you can sort by county. You can see a variety of the cases that we have available right now. And then if you're wondering, gosh, this was so wonderful, what do you have next? Well, we've got some fun stuff coming up. Our Tax Tuesday training is going to be about what's going on at the Maryland Comptroller's Office. On October 10th, we're going to have a training about discovery and evidence in district court collection cases. And then on October 17th, we'll have our next Third Thursday training, which is going to be tips from Bar Counsel. Lydia Lawless from the Bar Counsel's office is going to be here and talking about all those kind of fun things. And so still seeing no questions, which is fine. You can all check out the handout in the drop down under handouts. We'll get this recording uploaded to the website within the next few days. And then you're welcome to reach out to us if you need anything else. And otherwise, when you go in, when you close out of this, if you would be willing to let us know what kind of trainings you'd like to see coming up, that would be really helpful for us. We'd love to know what you're interested in seeing as we're planning our trainings for next year. So I want to thank Chris and Heather both so much for joining me, and I want to thank you all for joining us for this Third Thursday training, and I hope you all have a great rest of your day.
Thank you.
Thanks, everyone.